This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about why, no matter how sad the event or how much the judge feels for the plaintiff, an unambiguous exclusion in an insurance policy must be enforced. And even the wrongful death of an insured, a child, is excluded. And regardless of how much empathy a court may have for the loss of a child, it will not change the unambiguous language of an insurance policy. In B.H., Special Administrator of the Estate of C.W.H. versus Upland Mutual Insurance Company, the Court of Appeals of Kansas on August 16, 2024, needed to resolve a coverage issue when an insurer was asked to pay a judgment rendered against its insured, even though it believed there was a clear and unambiguous exclusion. Now, in Kansas, there is an action called a garnishment proceeding, where it does not create any contractual privity between a judgment creditor and the garnishee, but a judgment creditor seeking to garnish a judgment, that is, get somebody else to pay the judgment. The debtor's insurance provider, when the judgment creditor is not in privity of contract with the insurer and is not intended as a third-party beneficiary of the insurance policy, may only recover from the insurer to the extent the insured judgment debtor could recover. Now, the plaintiff's toddler tragically died from drowning in a pond at the child's foster parents' home. Mother sought damages from the foster parents, alleging they negligently caused her child's death. The district court found one of the foster parents, PB, 80% at fault for the child's death and awarded mother damages of $320,000, comprised of $120,000 for the mother's survivor claim and $200,000 for her wrongful death claim. PB and LB were licensed foster parents who received mother's child, C.W.H, as a foster placement in December of 2015 when C.W.H was about 1 month old. In August of 2017, when C.W.H was approximately 23 months old, he drowned in a tragic accident in a fish pond on the foster parents' property when only PB was home. At the time of C.W.H's death, Mother had been working on her reintegration plan, and C.W.H was spending 5 nights a week with Mother. The foster parents were insured under a homeowner's insurance policy issued by Upland Mutual. The policy contained the following exclusion, quote, bodily injury to you, and if residents of your household, your relatives, and persons under the age of 21 in your care or in the care of your resident relatives. Upland Mutual notified PB and LB of this refusal to provide coverage and defense, explaining that C.W.H was under the age of 21 and was residing in the household and was in the care of PB and LB. And also C.W.H was also an insured under the policy. After winning that judgment, Mother sued Upland Mutual, PB's homeowner's insurer, in the amount of the judgment against PB. The district court ordered Upland Mutual to pay Mother $200,000, which represents PB's proportional share of fault on her wrongful death claim. The district court agreed with Mother in part, finding no coverage for Mother's survivor claim, but finding the homeowner's insurance policy covered Mother's wrongful death claim because Mother was not an insured under the policy. The Court of Appeal then considered its only issue whether the district court erred in entering a garnishment order against Upland Mutual for mother's wrongful death judgment against BB, when the facts are undisputed. The court need not review the district court's factual findings and can proceed to the second step to review the district court's conclusions of law. Upland Mutual's fairly broad coverage provision is limited by a separate provision that states personal liability coverage does not apply to, quote, bodily injury to you and if the residents of your household, your relatives, and persons under the age of 21 in your care, close quote. The plain and unambiguous language excludes from coverage bodily injuries, including death to persons under the age of 21 that occurred while the injured was in the care of the insured and a resident of their household. The parties did not dispute that C.W.H. resided with the insureds and thus met this definition under either interpretation. And since the exclusion language in the present case is not ambiguous, it was applied as written. It is axiomatic that when the terms of an insurance policy are clear and unambiguous, the court must give effect to the parties' clear intentions and enforce the contract it made. And since the policy clearly excluded from coverage damages resulting from C.W.H.'s death, C.W.H. residing in the insured's home and under the insured's care and under the age of 21, the garnishment order for mother's wrongful death judgment needed to be and was therefore reversed. In my opinion, the loss of a child is horrible. Judges feel empathy, if not sympathy, to a mother whose child died as a result of the negligence of others. Judges seldom have empathy for an insurer who refuses to indemnify an insured because of an exclusion. The trial court ordered the insurer to pay in contravention of clear and unambiguous exclusion. The Court of Appeal reversed because the exclusion was clear and it needed to rule without empathy but on the law. This video was adapted from my blog, Zalma on Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. And you will receive notice of every blog posting, usually 5 or 6 a week. And you'll also gain access to the more than 4,850 blog postings. Please tell your friends and colleagues about this blog and the videos and let them subscribe to the blog and the videos. The videos on rumble.com and on youtube.com are free. And I'd appreciate it if you subscribe, and also would, if you view these videos, click on the like button on YouTube and the thumbs up button on rumble.com. And if you're interested in further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.